Good morning.
Well, good morning, everybody. This is just the way you want to start your work week. Welcome to WGL AM. It is Monday, March 23rd. Here we go again. Joined by my two wonderful guests, Miss Hannah Hill from the National Association for Gun Rights. Good morning, Hannah.
Good morning, Bill.
And, of course, Kostas Moros from the Second Amendment Foundation. Kostas, good morning.
Always good to be on. Thanks, Bill.
Thanks for being here. Now, listen, we've already gone over some protocol. If by chance Duncan gets denied today, we're probably going to have to take Kostas off the stage for a few moments because we don't want the whole country to see him throwing crap all around his house and stuff like that. And I have talked to the Moros family to make sure that there are no sharp objects in Kostas's near vicinity right now, just in case.
It's going to be an epic crash out. I'll probably get arrested outside Kavanaugh's house tomorrow.
Yeah. Excellent. Listen, for those of you,
that was a joke.
It was a total joke. It was a total joke. Yes, that's all right. Listen, for those of you who have been living under a rock, don't know what we do every Monday when we got these orders lists. We had a conference on Friday the 20th. We have been following 5 cases. Miss Hill calls them the Group of 5. We think that's a perfect name. Duncan v. Bonta, the granddaddy of them all, magazine ban challenge out of California. Gators Customs Guns versus State of Washington, magazine ban challenge out of the state of Washington. National Association for Gun Rights v. Lamont, challenge to Connecticut's assault weapon ban. Grant v. Higgins, also a challenge to Connecticut's assault weapon ban. And Viramontes v. Cook County, a challenge to Illinois, or actually Cook County, Illinois, assault weapon ban coming out of the 7th Circuit. Kostas has predicted we're going to have a per curiam ruling today.
That was a joke.
I know.
Unless it happens, then I take full credit for it.
Then you take full credit. If it doesn't happen, you take the post down, is what I understand
totally.
is how it's going to work, right?
Yeah, absolutely.
Yeah, exactly. Now, why don't you tell everyone real quick, because some people just don't geek out on this stuff, like a per curiam ruling. What exactly is a per curiam ruling?
It's a ruling without arguments and further briefing. It's usually they do it when they have what they see as a simple issue. It happened in Caetano about a decade ago with stun guns. It's unlikely to happen here, even though we think the issue is straightforward, just because it's so controversial that it would be a pretty ballsy move by the court. If it did happen, if somebody told me a per curiam happened, I would suspect it didn't totally decide the issue. They would probably say, this is what an arm is. This is the history you got wrong. Try again. I doubt we get a per curiam that would just totally address the issue. You know?
Right. And then 2 years later, we'll be doing another WGL AM, and those cases will finally be back before the Supreme Court with having nothing changed whatsoever.
Yeah. Let me start refreshing because we're at 6:30 now.
All right.
I guess.
It's 6:30 for us on the Hannah's got it. Now, guys, I just want you to know how excited I am to be able to do this in the studio today. It's been a few weeks since I got to do this in the studio, although it is a little earlier out here than the other places that I've been able to do it. And I was down in Tyler, Texas last week, and really beautiful part of the country down there.
Yeah.
So while we wait, oh, there it is.
All right, here we go. Take a look. Pulling it up. Well,
No Lamont. No Duncan.
No Duncan. Yeah.
Viramontes.
Nothing. Yeah, it looks like another nothing burger.
Another nothing burger. We have been serving up a steady dose of nothing burgers here on WGL AM. One of these days, listen, at one of these days, we do get a thumbs up and a thumbs down. It just depends on when it's going to happen. So we're going to do a quick search on it. Again, for those of you just jumping in right now, all 460 of them, thank you very much for starting your work week with us. The orders list is out. We are doing a quick word search over the orders list. We will link it up in the description box for those of you who watch this on replay. So if you want to check out the orders list and see what it's like. It's not the most sophisticated of documents. It looks like it was made on like a Smith Corona typewriter still. So we have nothing on Duncan, nothing on Gators.
Yeah.
Hannah, your eyebrows just went up. What was that?
Am I reading this right? I don't think they took any cases today.
No, they didn't grant anything.
Well, they're keeping the workload light at the United States Supreme Court right now. So
they did a few per curiams, it looks like, just not anything we care about. Yeah,
one of those gave me a bit of a pause because of the word investigators. You're doing the Control F search for Gators guns.
Yeah. You know, the Gators case, I got to be honest with you, the Gators case, I had an opportunity to be part of that as it was going on. That is a really, really well-developed record. Do I think it deserves to be extended? Yeah, but do I think Duncan deserves it more than Gators? People in Washington are going to kill me for saying this, but yeah, I think if there's ever a case that should decide platform bans, it should be Duncan. It really should.
Yeah, it's just going to come down to the problem, or maybe the asset of Duncan. It depends on the way the court looks at it, but it's about magazines, and we don't know yet if this court thinks magazines are scarier or less scary than AR-15s, because you could argue it both ways, right? There's a universe where I always go back to one of the Heller decisions where Kavanaugh, in dissent, said he disagreed on AWBs, but he said he would have remanded on magazines to see if there's any tradition or something supporting their ban. So I'm wondering if Kavanaugh's not solid on magazines. I guess we'll find out. But you could also look at it the other way.
Wait a second. Kavanaugh, the same one who wrote this kind of apology letter last time around, say, well, we'll probably get around to this the next year or two.
Saying AR-15 case, AR-15. He didn't say magazines. And also saying AR-15 bans are unconstitutional, but allowing magazine bans is like the most John Roberts thing ever. He would love it.
Exactly.
You know, it absolutely would be.
They'll have to make proprietary 2-round magazines for California coasters.
I know it's ridiculous, and I hope I'm wrong, but I could totally see that being a Justice Roberts thing to do, you know, like split the baby kind of thing. But yeah, we'll have to see if they're, because you could look at it the other way too, which is, but, you know, it's just a pistol magazine, you know, a 15-round Glock 19 mag. Let's decide that. That seems less threatening than, you know, AR-15. So I don't know which way they look at it, or they'll want to wait and take both of them together in a single case, which would be like the Illinois cases. I think the New Jersey cases like that. So we'll just have to see.
Well, and before we went live, we were talking about, like, if the can gets kicked, are they just waiting to see what happens in the Third Circuit with Cheeseman? Are they still waiting to see what happens in the Seventh Circuit with I think it's Harrell v. Rowell and Barnett v. Rowell out there? Now, I having listened to the arguments and talked to people who are in the courtroom in the Seventh Circuit, there's a puncher's chance they can win that 3-judge panel ruling. But we know an en banc panel is going to snort that thing up like, you know, a scene out of Scarface, right?
Right.
And once they get their hands on it, what do we think the full Seventh Circuit's going to do with it? Whereas with the Third Circuit and Cheeseman, once that ruling comes out, there is nowhere to go except to the United States Supreme Court on that case.
Yeah, that's that one. That one will be done. There'll be no more games to play unless the Supreme Court wants to ignore a circuit split, I guess.
And they seem to indicate that they were wanting to rule on it decisively and quickly, because again, you know, they took that one before the 3-judge panel had a chance to rule. I think we could read an implicit promise into that, right?
We'll see.
Well, one would hope.
One would hope. I know it doesn't actually work that way, but they get everyone's hopes up like that. So you say any day now, though, right, Bill? Well,
I mean, listen, the third, it's been 6 months since the Third Circuit heard that, and the rumor is that they traditionally are one of the speedier circuits when it comes to releasing opinions. So one would hope. Are they going to drop it in the middle of the summer when they think it doesn't get as much news coverage, just like the United States Supreme Court always drops its really big rulings right as all the justices are getting out of town for summer vacation? I don't know. Speaking of over quick, I want you to know that there was actually 18 Second Amendment cases before the United States Supreme Court on conference on Friday. We weren't following all of these. One of the things that Kostas has taught me, I've learned a lot from him, but when a case, it gets petitioned and the other side says, hey, we're not even going to file a brief, and the court never has a beef with that and sets it for conference, you are probably a dead man walking at that point. And so every one of these cases, including Mississippi Rod and Gun Club,
got denied. Yeah.
and Kostas, I don't expect you to check all of these. We can check them a little bit later on, obviously. But these were all cases that were coming up on first conference today, all of which had recently been filed, and none of which was a reply brief requested by the United States Supreme Court. So I think we can all say that those cases are living on very borrowed time. Agreed?
Yeah, I just looked up a few of them, including Sinisippi, and they're denied.
Yeah. So, hey, welcome to the party to all of these plaintiffs here. Hope you enjoyed your stay, but it is over now, and you can continue to tune in and watch WGL AM. We will continue to follow other cases. You will go back down to the lower courts and deal with that. A lot of them are 922 G1 challenges. There was a couple of interesting things. Ali versus Portland was a very interesting unlawful shifting of the burden about unlawful carrying. It was an interesting case. Taylor versus United States was a case we were going to talk about a couple weeks ago, and then I kind of skipped out on it. That was going to decide the question of is a firearm with a Glock switch really an automatic weapon as defined by 922-0. I'm sure the court was just chomping at the bits to get involved in that one.
Right.
Let me since we have a nothing burger today, and I got you guys here, I want to ask your expert opinions on a couple of other things. This is a case I have followed very closely, Schoenthal v. Raoul. This is a case out of the Seventh Circuit. It is a challenge to Illinois' public carry ban on mass transportation, public transportation. And the ruling in there is really a tough one because it basically carves out this rule of law. Well, if it's a crowded place, of course it's a sensitive place. Of course we could disarm there. That case was actually scheduled to be on conference for today, but about a week and a half ago, there was a docket entry that just said it had been rescheduled. No, I take that back. It was actually scheduled to be on conference on March 4th, I believe. And then it was rescheduled. And now it's just kind of sitting in rescheduled purgatory. But we've kind of developed a theory that this might be setting up for a GVR. Kostas, you want to kind of fill everyone in on where we're coming down on that?
Yeah, sure. So this one has been actually rescheduled once. It was distributed for its first conference on March 20th, and then it got rescheduled, but we haven't gotten a new date yet. So if another week or two passes and if it's set for this week's conference, then it was probably just some weird scheduling thing, no big deal. But if it doesn't get rescheduled, that probably means that they're setting it up for something likely a GVR after Wolford. And that usually happens when they think a case is going to influence another case. So if they say stuff about sensitive places in Wolford, and they think that'll be material to Schoenthal, then they're not going to decide Schoenthal right now, but they will hold it and then GVR it later. So that means grant, vacate, and remand back down to the Seventh Circuit and say, try again. And the Seventh Circuit will reach the same exact ruling because they don't care. But that's the charade we're going to go through. Unless the Supreme Court is very clear in Wolford, which I doubt they will be, then I suspect it won't make a difference, but it's still good for Schoenthal because that's better than a denial.
It's absolutely better than a denial. Yeah. Let me ask both of you this, though. Why, with all of these 922 G1, which are felony with firearms, prohibited people, why didn't we see a big log jam of them to see a GVR post Hamani, which would have been in the ballpark? We're talking about gun laws only ban people, places, or things, right? And so this one, Hamani's about people. All the 922 G1 cases are about people. Why do you suppose we aren't seeing all of those accumulate for a GVR?
Well, before we heard Hamani, I thought it was because we were going to lose Hamani.
Right.
And
right.
Like, well, Supreme Court figures why hold these? Hamani's going to lose, so no big deal. Now my theory has shifted. I mean, we still could be wrong because sometimes oral argument's deceiving, but I suspect we're going to win to some degree in Hamani. But what I think the reason they're denying all these is because in the few that the government was forced to respond to, they basically said, hey, Supreme Court, don't worry about these because we're making a rights restoration process. It'll be ready soon. And that'll be an avenue for, truly nonviolent, not threatening people to get their rights back. And I think that was good enough for the Supreme Court to punt on these and say, no, we're not going to deal with these. And, if that system doesn't work out, then we'll deal with it later kind of thing. Yeah. But because a lot of these people now are soon going to have a process to get their rights back, well, the Supreme Court loves dodging stuff. So if it gave him an excuse to not deal with this, so perfect. Hamani, though, the government, he wouldn't be eligible under the new system. So that's why I think they took that case. Yeah.
Hannah, let me ask you this, though. If that's what the Supreme Court is doing, what one administration giveth, the other administration can taketh. And you've been through this. You're a political creature. You know about the shift in political winds. What happens? Okay, so we got 925C refunded currently. We still don't have infrastructure in place or a game plan yet. We're still, apparently that's a work in progress. But what's to say if there's not a shift, change in political administrations that poof, it's gone?
Well, this seems to be an area of public official discretion in the doling out of gun rights that the Supreme Court seems to be fine with. You'll remember that was actually one of the key issues in Bruin. They said that basically your gun rights, your permitting rights, should not depend on going before a local sheriff and having him just say, no, I don't think you should have them. Well, but that's the situation you have here when you have a categorical ban for people who shouldn't have their rights stripped in the first place. And then you have to go before the Attorney General, and the Attorney General says, you know what, we're not in the mood today. And that's the best case scenario, right?
Yeah.
We know there are going to be a lot of people under a friendly administration when the infrastructure does finally get established. There's going to be a lot of people who ask for their rights back, who deserve to have their rights back, who just either because they fall into the backlog or it never happens. And we don't have much time before the midterms. And then assuming, the results are good there, 2 more years of this. And then God forbid a Gavin Newsom presidency. Yes, they don't even have to do anything. All they have to do is stop. All they have to do is stop prioritizing this as the Attorney General, whoever that is. And then, the whole option dries up. That's why that request by the DOJ to withhold categorical relief is really a bad faith argument in my view. You don't strip away gun rights and deny them their day in court, really, to say, should this categorical ban exist, because we're going to be doling them back out to a few people piecemeal. That's not the way the rights work. And when it's New York, the Supreme Court recognizes that, but apparently not the DOJ.
Well, what I want everyone around the country to be aware of, if you are a person who has a little strike in the past, and as a criminal defense attorney, trust me, I get how people screw up at a younger age. It can be a radically different person.
Yeah.
We all grow up sometime, just takes some of us longer than others. But you are going to want to strike while that iron is hot. When there is an opportunity to restore under 925C, you do not know. The window could be as short as until the next inauguration day. Okay, so once that rule is in place and the infrastructure is there, my advice to anybody who falls into this category is get on it right away. You're going to want to contact local counsel, someone who really understands how to restore, because you got to restore on a state level, you got to restore on the federal level as well. So you're going to want to have a person that has some local expertise there. And if you start talking to them about 925C and their eyes start glazing over, probably time to call the next different attorney and see what that they know. But this is really important because I mean, you see these cases, food stamp fraud from 30 years ago, or a misdemeanor where the punishment was actually could have been more than a year, but they got like 20 hours of community service from 22 years ago, and these people are still disarmed. So this is a problem that needs to be fixed.
And if I could add to that,
yeah, please.
You should also formulate your petition to the DOJ with the assistance of counsel as well. We've had a lot of people, and I say this lovingly, we've had a lot of people contact us sharing their stories. You are not the best person to formulate and frame your story to get a swift and sympathetic hearing at the Department of Justice. You're not objective, and you don't know what factors are going to immediately sound like red flags to them, even though they sound compelling to you. So you need to talk to an attorney when you go to the DOJ, and you also should talk to an attorney, like Bill said, when you're asking if this is going to restore your state level rights, because it would be a real shame to go through that entire federal process and then realize that only took care of the federal prohibitor. You still got a state prohibitor.
Well, the biggest problem I have here with folks in Washington, our restoration process in Washington is remarkably straightforward. And I get people all the time, it's like, I hired this lawyer a few years ago. He said he got my rights restored. I even got an order that says it. And I just went to buy a gun and I got denied. Well, yeah, they got their rights restored on the state level. They didn't do it on the federal level. You're not passing background checks still. And I got news for you. If you got an order that says your rights are restored, you're not passing background checks, your rights aren't restored yet. So that's why there's a lot of nuances, and every state is different. So I want everyone to just kind of be aware of that. Hey, let me ask you guys this real quick. I'm going to put a call out to the one gun store that I could find inside the District of Columbia. I don't know if you guys have seen this, but apparently there is complete chaos, pandemonium. It is absolute death and destruction going on in the District of Columbia right now. Trump may have to call back in the National Guard, as I understand it. It's getting so chaotic there. But have you guys seen the now going on over a week, the tantrum that the District of Columbia Attorney General's office has been throwing over this Benson ruling?
Yeah.
It's pretty epic. I mean, they're asking for stuff that's not even in the rules. You know, they're asking them, oh, you have to not only stay the case, but stay the precedential value of the case until the en banc is decided. And then, oh, okay, we've petitioned for en banc, but you shouldn't even give you shouldn't give Benson a chance to respond to it.
Yeah, there it is right there. This court should grant rehearing sua sponte without ordering a response. This would be like me, and I got court this afternoon. I'm not going to try this, I promise you. But if I walked in, it's like, Judge, I'm going to make a motion, but I'm going to ask that the state not even be heard on this. Well, first of all, my win-loss record would go up significantly. It really would. But I couldn't even imagine doing that. And in addition to that, they say that although this is an unusual request, it's actually an unlawful request. The effect of the division's decision on public safety has been extraordinary and immediate.
That's probably why they didn't want response. They wanted that statement to go unchallenged and unrefuted because it's
Well, so I yesterday I was Googling and I was like, how many gun stores are there inside the District of Columbia? And I found one for sure, possibly a second. They're both closed on Mondays. So I'm going to try to call them because I just want to know what the death, destruction, pandemonium, and chaos that's going out there. I also want to know how much money these FFLs are printing now because they're able to blow out 50-round magazines, which we all know is not what's going on out there.
I mean, the argument's ridiculous on its face because I think they say at one point, well, you know, people could just go to Virginia across the border and buy magazines. I'm like,
till July 1st.
Criminals could already do that. Dummies.
Yeah.
Like they've been doing that. People who ignore the law don't care. So all this is affecting is people who aren't going to break the law anyway.
Yes.
So it's so silly. And I guess, you know, we're going to know now pretty soon what's going to happen in Benson because if the DC Court of Appeals grants en banc, then they're reversing it. Like if
Absolutely.
You know, especially if they grant it and also stay the precedential value of if they stay the precedential value of it, then it's for sure we're losing. Like there's no chance. We may as well not even pay attention to the case anymore until it gets to the Supreme Court. But you know,
what is the method to remove precedential value on a published opinion? Right.
There is none. So at least not in DC. So if they do that, then it's as good as it's as certain as a loss as there is. Because if they take an unprecedented move to impede the case, then do you think we're going to win the en banc? Like, come on.
No. Let me ask you this. There's a lot. There is at least one other person in our sphere, content creator, who believes that the en banc panel will not accept review because en banc review is so rare in the District of Columbia.
I hope that's true.
Yeah.
But 0.1% of all cases in the Ninth Circuit get en banc review, but every Second Amendment victory has. The DC Court of Appeals.
Well, that's it. He's right, though, because he's broken the stats down on it. Kostas has the stats on that.
Yeah, I did. I put it in the brief for the case they're hearing tomorrow, Ukitaki. So, we'll see. Maybe the DC Court of Appeals is legitimately different. Maybe they're less partisan, and maybe en banc is denied. I'll be so happy, and a little bit of my faith in the courts will be restored if that happens.
Wouldn't that be funny if the most non-political court in the country would be in DC? That would be pretty amazing, wouldn't it?
Yeah, it would be. I mean, the judges are pretty not as partisan as you'd normally expect because the way they get confirmed to that court is very strange, and it's a lot of career types. So you know, we'll see what happens. I mean, I don't think you can draw much from who appointed them. Is all I'm saying, because a lot of these judges were appointed by presidents, but previously appointed by a president of the other party. So it's a really weird partisan mix. You can't really tell who's who.
Well, and if that's really what's going on, what you're probably avoiding is the hyper partisan
Right.
judges, right? You're getting a lot more that are a little more middle of the road. And so it may be a harder prediction. When you take a look at the Supreme Court level, that is a very, very hyper partisan process.
Right. Right.
Well, there's one good thing that came out, a couple of good things that came out of this little freak out that DC is throwing. It's a real bless your heart moment, honestly. But one thing, so we know for a fact that if they lose the en banc round, either they don't get it or they lose that appeal, they're going to take it to the Supreme Court. And number two, they're not great lawyers. So when it gets to the Supreme Court, the deck's going to be stacked even more in our favor. So if it's going to go to the Supreme Court, you want people who are not excellent at crafting their arguments and shaping the procedure.
Or who can't divorce themselves from their emotional reaction and think in an intellectual fashion. I mean, this is really like that spoiled kid whose parents never told them no and then finally put their foot down and said no. And they are just having a conniption fit right now. They are a complete tantrum, a meltdown of epic proportions.
Well, I like Kostas's point that you made on Twitter. They're pointing to Freedom Week in California, but there was no pandemonium. There was no, and they're like, see what'll happen in California is going to happen here. And yet
nothing happened in California. I mean, in the suppressor case, Sanchez v. Bonta, oral arguments last fall, California, it was the most bizarre thing. They admitted that it came out of nowhere. They're like, well, we can ban magazines, even though magazines with high capacities aren't often used in crime. And I'm like, did you just say that in court?
Yeah.
So I mean, they've admitted that these aren't some big criminal threat. And so, I hope the DC Court of Appeals doesn't fall for this. And if they do, I don't think they're falling for anything. I think they're in on it. So
I agree. Well, I think Kostas, you raise a good point, which is even if historically speaking, the DC Court of Appeals doesn't take a lot of en bancs, that's when we're taking a look at their whole body of work.
Right.
But what we are talking about is a very specific issue, the Second Amendment, just like you pointed out with the Ninth Circuit. En banc review in the Ninth Circuit in general is rare. Mm-hmm. When it comes to a Second Amendment case, though, it exponentially goes up. It almost comes from like the odds of you getting struck by lightning to the odds of you dying someday. It's almost it's literally guaranteed at that point,
Yeah, I mean, it's only Nguyen. Nguyen is the only Second Amendment panel victory that was not reversed en banc in the Ninth Circuit.
And that's out of 51, I think, is what you're.
Well, now it's up to 75, but that's all Second Amendment cases.
But hey, who's counting?
I'm talking about the panel victories. So the times when we won in the panel, they always get reversed en banc. There's 10 of them now, 11, I think, with Rhodey, 10 or 11, somewhere there. And so every single time that's happened, except for Nguyen, it's been reversed en banc.
You guys got Yukataki coming up tomorrow for orals?
Tomorrow, and then Rhodey on Wednesday. It's en banc week at the Ninth Circuit.
It's en banc week. Oh, boy. Why don't you tell everyone real quick what the issues are in both Yukataki and Rhodey? So they can follow.
So Yukatake is one of Alan Beck's cases, and that one is Hawaii's process to purchase a pistol. So it used to be you'd get your pistol permit, and now it's you get your pistol permit and you have 30 days to purchase a gun before the permit expires. It used to be, I think, 14, but they extended it in response to this lawsuit.
Very generous of them.
After you get your pistol, you have to take it back to the police station for inspection within 5 days so they can make sure it's not somehow illegal, even though you bought it from a gun store. I think so. Anyway, that's the crazy process that's at issue in Yukataki. And then Rhodey is California's ammunition background check, where you have to do a background check every time you buy ammo. It costs $5 each time, or $19 if you've moved since you last purchased a firearm. And it wrongfully denies 1 out of every 10 people who use it. And it's crazy that this might actually survive.
Well, yeah, because it was struck down by a 3-judge panel, and almost immediately the full en banc came in and took that one, right?
Yep, same with Yukataki, yes.
A la exactly what we were talking about.
Yeah.
Well, listen, guys, because I was worried that we could have a nothing burger. I did go back through and take at some new petitions. We got a new section we're going to call. This one's called "Welcome," but don't get too comfortable. These are new petitions that will have the life of a mayfly. And here they are. And again, if you're counsel for one of these three cases, number one, thank you very much for tuning in. Number two, come on back and keep watching, but we're not going to be talking about your cases in all likelihood. Mackins versus the United States, Ramirez versus the United States, both 922 G1 challenges. Haven't seen those before. Abercrombie versus the United States, a pretty interesting issue. But, and again, I mean, no disrespect for the council, but I think they completely missed the boat on what the issue is and how they framed it. It really has to do with the constructive possession issue. And really what, it's one of these, we found a gun in the car and there's one bad dude in the car, so we're going to pin the gun on him. And they really don't have a lot of other evidence to suggest it's his firearm. Pretty interesting issue, but these are going to end up like these cases right here that we saw earlier today. This is going to be a wave response set for conference. Thanks for playing the game. And here's a board version of the take-home game for you or something like that. So another case I did want to draw your attention to, I want to draw everyone's attention around the country to it as well, is a newly filed matter in New York, Southern District in New York by FPC, Johnson versus New York. This is a challenge to Times Square being no, this is not. Let's go back. What is this one? I got that confused. Oh, yeah. Okay, let's talk about Johnson versus New York. I want to read this one. Omar Johnson was prosecuted for possessing a firearm for self-defense purposes without a public carry license in New York under the very regime that the court considered in Bruin. Mr. Johnson argued that his unlicensed possession was a direct result of New York's unconstitutional proper cause standard. Okay, so that's why he was denied. The New York Court of Appeals rejected it on severability grounds, finding that New York's other licensing requirements could continue to be enforced against Mr. Johnson, notwithstanding his undisputed inability to satisfy the proper cause standard. The question presented is whether or under what circumstances individuals can be criminally prosecuted for failing to comply with a licensing scheme that contains a facially unconstitutional licensing standard.
Wow.
It's an interesting issue, isn't it?
Wow. That reminds me a little bit of that Virgin Islands case where basically they're just operating down there as if Bruin didn't exist and the Department of Justice filed a lawsuit to enforce it. Seems like this one would be a right instrument.
Now, is New York's argument that he wouldn't have gotten a permit anyways because he failed?
New York's argument was he never bothered to apply and therefore he doesn't even have standing to bring this challenge.
Right, but I mean, there's always the argument. I know courts love to be selective in how they enforce it, but
futility.
Futility. But a counter to futility sometimes is, well, if you had applied, you would have been denied not because of the proper cause, right, but because of the good moral character, or you have criminal history, or whatever it is. So I'm wondering if Mr. Johnson has something that would have disqualified him.
Did not dig into it enough. Obviously, if he's got a issue with good moral character, oftentimes what comes with that is also criminal history.
Right, that's what I mean.
Yeah, agreed. So I'm going to dig into it a little bit more, Kostas, and see if this one's actually worth putting on our radar. Right now, it's just an interesting case. Go ahead, Hannah. I interrupted you.
It'd be interesting to see also when he was arrested for it, because if he was arrested after Bruin, then his argument for not even applying for the permit goes down significantly. That's
true.
But still, it's a weird
point.
If that's the case, though, it's really weird that they're relying on pre-Bruin legal reasoning for the prosecution. Because now that at this point they've got an open shut case, and that's even stronger against him because he could have gotten a permit in theory.
Yeah, we'll have to see.
We'll have to see. All right. Well, guys, the next time we got a conference next this Friday. I'm telling you, if they take these group of 5 cases and just kick them over to next Friday, I'm just going to be rolling my eyes. This is getting it. But we got March 27th, we got April 2nd. So next 2 Fridays, we got conferences coming up. We have no word on what's going to happen with Cheeseman. That to me is the big deal. If we can get a ruling out of Cheeseman, and if it would go the way we think it's going to go, then don't you think the world just kind of shifts under our feet as we analyze this stuff?
Yeah. I mean, At that point, it'd be very hard for the Supreme Court to deny cert. They still could. They've ignored circuit splits before, but at that point, you know, you have Justice Kavanaugh telling us that they're going to decide this soon, and if you have a circuit split too, then I don't know how they keep dodging it. Yeah.
Well, and one hopes that the court is actually aware of the results of denying these cases. Like, you know, they denied Snope, and that was basically a green light to other states to expand or pass new gun bans. We're seeing that happen in a number of places. And it's hard to argue. I mean, yeah, Rhode Island had their magazine ban denied along with Snope last year, and now they're in the process of passing an assault weapons ban. What are you going to
Well,
tell
no,
them?
actually, they're doing something even worse than that. They passed their assault weapon ban, which only banned the commercial sale. Now they're amending the statute this year to add one word to it,
Confiscation.
which is possess.
Yeah.
Right. So now, yeah. So there, if that goes through, we're going to literally have videos going on, countdown to confiscation in Rhode Island, countdown to surrender, whatever it's going to be. But you're going to have a lot of people hanging on to things that will become illegal overnight.
So if the Supreme Court denies this group, then that's, again, going to be a legislative mandate, if you will, to, you know, all the deep blue states and even the purple states, that they can have at the Second Amendment with impunity. So one hopes that that's why they're at least holding on to these, even if the Third Circuit case is the one they're waiting on. And now we've got the Hail Mary out of the DC Court of Appeals that we're hoping will come through for us, even if Cheeseman takes a while yet. But, you know, the longer they hold on to these, at least the longer they stave off the negative downstream legislative consequences.
Let me ask you guys this one. Put your thinking cap on. It's like a law school problem. Hannah, I know you didn't go to law school, but I've always told you should have, because you missed your calling. By the way, Hannah Hill and Todd Vandermeide over at Freedom Steel are the best two non-lawyers for breaking down legal cases. Their legal analysis is really, really good. Okay, here's today's question. We got Benson versus United States. The District of Columbia's Court of Appeals said magazine bans are unconstitutional. But on the federal level in D.C., we have a ruling that's the opposite. But that ruling was at an interlocutory phase. It was on an injunction hearing. So the ruling there is that the statute is likely constitutional versus what we have in Benson, which is, no, the statute is unconstitutional. Now, let's say this other 2A content creator happens to be right, and DC just doesn't take en banc. And so Benson ends up being the ruling. Which one controls?
Oh, they can't enforce it. So
Yeah.
that's why it's effectively a circuit split, even though it's not technically a circuit split, because the result is the same. DC's in this unique situation where their state court and their circuit court are the same. They cover the same territory. It's not like, you know, if the California Supreme Court disagreed with the Ninth Circuit, because the Ninth Circuit's bigger than California. This is effectively the DC Circuit Court of Appeals, even though it isn't, you know? So if the Supreme Court, if they go to the Supreme Court after that, first of all, I would expect they're going to shift their tone. Because could you imagine if they get demanding and start stamping their feet in the Supreme Court? But
listen, by the way, did the District of Columbia Attorney General's office do it? Please do exactly that.
I imagine they're going to get angry, frantic calls from California and others saying, "Don't appeal this, don't appeal this." You know, because I don't know, maybe not, because maybe California and others are smart enough to know that, like, this is on its way to the Supreme Court. The Third Circuit ruling's coming, so I don't know how much they can really stave it off. But yeah.
Well, and also you make a good point. So permission, likely constitutional, is not a mandate, right? It's permission to do it, but then if the lower, more immediate state equivalent
on final judgment,
says you can't, then technically, in that sense, they don't actually conflict.
Yeah. I agree with that. See, look, I told you Hannah Hill should have been a lawyer. Look at that legal analysis. It's thorough every time. All right. Hannah, what do you guys, what's NAGR got coming up this week?
Well, today is actually our former lawyer's first day at the DOJ. Barry is starting at the Department of Justice today. So he goes with our best wishes, and we're going to be sending him case suggestions. I might see if he's noticed this one that you just mentioned, Bill. So we'll see. I
might text Barry. I won't get a response until post business hours now, because his cell phone's probably off while he's inside DOJ. But
So you heard it here first. Everything we don't like at the DOJ is now Barry's fault.
Yeah. Listen, I've been a little public about this. I know Hannah's been a little public. Barry Arrington is as good a brief writer as you will find anywhere in the country. And while it is a tough loss for all of us that work with NAGR to see Barry depart, it is America's gain. America has won here because Barry Arrington is a warrior, not only for Second Amendment rights, but for all your civil liberties. Okay. And Barry is incredibly passionate about this stuff. I've had an opportunity to have discussions with him about a lot of other big legal issues outside the Second Amendment sphere. America, if we had more Barry Arringtons in the Department of Justice, this country would be a better place. So I'm sure Barry doesn't get to watch this on a DOJ computer. Maybe he'll catch it on replay tonight. Barry, best of luck to you. Keep in touch. Don't be a stranger.
And that's also, while we're very rightly proud of him, obviously, and feel invested in this, but I also want to emphasize the reason we haven't seen more Second Amendment activity is simply because of how short-staffed they are. So the fact that he's starting now, and he really is like a one-man army when it comes to brief writing, the fact that he's starting now and he brings a wealth of Second Amendment expertise. He's the old broom that knows where all the dirt is, right? Don't tell him I called him an old broom. The fact that he's starting there means it's kind of a new era of the sky's the limit at the Department of Justice, at least in the Second Amendment division. A lot of the other things that the DOJ is doing on Second Amendment issues, particularly where they're the defendant, that doesn't go through Harmeet's shop, as we know. But we're expecting to see a lot of really good and exciting things and possibilities coming out now that they're really beefing up their staffing.
I agree. And the dude cranks out a brief faster than anybody I know. I can't believe how quick his turnaround times were on briefs. It's ridiculous.
Excuse me? Faster than anyone you know?
Well, I don't know, Kostas. I've never put you on the clock. You pretty good at it?
I don't think anybody's written as many amicus briefs as I have in the last 6 months.
You have, man. You've been an amicus warrior, dude. SAF's getting their money's worth out of you. There's no doubt about it. So, for those over at Alan Gottlieb, you probably owe Kostas a raise.
No, you don't. But
come on, Kostas, you got to learn to advocate for yourself. You didn't have to say anything. You could have just nodded along there for that, though. I'm just trying to make you more money, man.
I appreciate that. I was actually checking because speaking of DOJ, we have the Rody en banc arguments this week, and they did an amicus brief. What I don't remember is if they're going to be arguing at Rody. I can't remember if they are or aren't.
I don't remember hearing that they were.
So maybe they're not in this one, but yeah, they did a brief. So
it was a really good brief too.
Yeah. So
what else does Kostas? What else does SAF have coming up this week, other than the two cases already talked about, Yukataki and Rody?
Right. So we've got I'm going to be doing live tweets on those. Today, this evening, actually, if I'm still awake, I'm going to be having a debate with my friend, Charles Nichols, who all of you have, I'm sure, had pleasant interactions with. He's the very hardcore open carry guy. I'm excited for it. It'll be a good discussion. And later this week, I think this week, we're going to be filing an amicus brief in Peterson, which is a new Supreme Court petition that got filed. That one is the suppressor case out of the Fifth Circuit.
That's the one where they originally said Second Amendment doesn't cover it. Then DOJ changed their tune, and then the Fifth Circuit kind of sort of changed their tune a little bit.
Versions, yeah. So then they revised their ruling, and then they revised it again after an en banc petition to very slightly change it. So yeah, I don't know how.
What do you think about the facts on that one? Do you think that's a strong case?
Yeah, it was before the tax got lowered to zero, and I don't know. I'm not. If you're asking my honest opinion, I don't think it's going to be granted cert. But we always shoot our shot anyway, so that's why we're doing the brief. I don't expect, if the Supreme Court's struggling to take an assault weapons case, that they're going to take a suppressor case or an NFA case. But that said, we always argue for it, and we'll see what happens. We're doing our brief, and the way we're going to frame our brief is the court can decide three big issues with this one, which is what is an arm? Suppressor should count. That would be on the edge of that. Whether registration is okay and whether taxation is okay, because this still involved non-payment of the tax. The tax is now zero, but at the time it was 200, whatever it was. So it would be a great case to grant cert on. They won't, but but it would be a great one. So that's what we're going to argue. And I hope they prove me wrong. I hope they take the case. I think the best hope for Peterson, frankly, is a GVR. The problem is I don't think it'll even get that because this is not a traditional hardware case. It's, it's more about the taxation and registration.
Well, he has a better chance of it too if the DOJ was still standing by their suppressors aren't covered under, they're not armed, so they're not protected under the Second Amendment. Now they've shifted to, or from the right to possess, we can ban possession, to you can possess them, but we have the right to regulate them. And I just don't see the Roberts Court having a problem with that argument.
Yeah, and they took a weird stand. I don't know if I can't remember. I need to go back and read their brief where they revised their position. I don't remember if they exactly said suppressors are arms. They might have said like they're not arms, but they enjoy some degree of Second Amendment protection, so they can't be banned, but we can register and tax them. I think that was their. Yeah, I think that's what it was.
Well, that creates a dangerous middle category of it's kind of, sort of, kind of an arm.
Yeah.
So we can kind of, sort of give it maybe protection if we feel like it.
Yeah, I missed that part of the Second Amendment where they said, but kind of, sort of arms can kind of, sort of be infringed.
Yeah, it's not the Second Amendment. That's the half amendment. You're almost there at that point, right?
Yeah.
Our video coming out today is for the folks in Virginia. You might want to grab a barf bag when you watch it, Virginia. 11 gun bills headed to the governor's desk. 11. And I don't see how she's going to veto a single one. Got to remember, a lot of these bills were passed last year, and Youngkin vetoed it. And so to all the other folks around in some of these other states, as Kostas and I like to call it, behind enemy lines. And in particular, I'm speaking to you, Colorado. Okay. Every year, your state legislature kicks around something. Everyone in Colorado has a 5-alarm fire. Oh my God, the world is coming to an end. We got it so bad out here. And I get it, it's bad. I'm not saying what's happening is bad, but it's mildly comical with you folks out in Colorado. Because if you really want to know how bad it can get, if you really want to know how rotten a legislative session is, you need to look no further than the state of Virginia. It is absolutely, it is like a mass extinction event that has occurred out there. So I want everyone, and listen, there's going to be a lot to talk about in Virginia because lawsuits are going to start falling. Kostas, you and I have already said, but the circuit sitting on top's not real good. But again, you miss 100% of the shots you don't take, right? I
mean, look, on the hardware case, I don't know about the other cases, but on the assault weapons case, SAF might file a lawsuit as well, I believe. But it's just another ticket to the Supreme Court. Like, we're pretty much going to argue, like, all right, hand us our loss so we can work our way back.
Yeah, let's just get into the system and go, right? And you got to take your lumps to get there.
Yeah, pretty much you're signing up for, if there's a mass GVR, maybe you get some attorney's fees for them forcing you to do this nonsense. Like that's pretty much what, unless, God forbid, if the Virginia case was the one the Supreme Court heard, that would mean we've had a terrible couple of years of them denying everything. So
that would tick off a lot. I mean, we need the issue resolved, but man, if they end up taking the Virginia assault weapon ban when California's been living under this crap for like 2 decades now, God,
so
really?
Frustrating. That would be so. But yeah, I mean, as for Spanberger, like, I could be wrong. Maybe she'll sign them today. Who knows? But she's been real quiet about it. And so, as Rob Romano pointed out, so have the gun control group. So I'm wondering if the message went out to shut up about it for a while, because what's going on in Virginia right now, separate
redistricting
gun rights, is the redistricting vote. Yeah. And so far, I'm not going to make any predictions that our side's going to win that, because there's just so many people in Northern Virginia. But so far, it is the rural red counties that are like blowing the roof out on turnout. Like, they're really angry over there. So it could be that Spanberger sees this and says, oh shit, like if I start off my new governorship with a statewide loss, it'll really like hobble me, my political capital right out the gate. So maybe she's stalling on signing these until the last minute. Some people said, like, if she doesn't sign them, they become law after 30 days. That's how there's no pocket veto in Virginia. But I think everyone can see through that. Not signing them is as good as signing them. So what she will probably do is sign them last minute, have her press conference then, but with less time left for people to get out and vote. I could be wrong, though. Maybe she'll sign them today.
Well, but let me ask you guys this, Hannah. This might be more in your wheelhouse here. How can she have a signing of all these bills without just making a big production out of it?
I don't see how. I mean,
right?
everybody who elected her knew what she was and what she was going to do when they get in there. And I think, even keeping it quiet till the last minute, I mean, that's only going to do so much because everyone's, as soon as she was elected, we all knew what was coming.
Yep.
Well,
So
that's not what she ran. Like, yeah, we
No,
knew.
she didn't run on. No,
We
that's
knew,
right.
but what she ran on was, I'm going to be normal compared to Trump's craziness, and I'm going to lower your cost of living. Well, the first thing they did was gun control, which they didn't really run on. It was de-emphasized, and they've been raising a bunch of taxes. So people
They're going to
pissed
tax
off.
their way back to affordability in Virginia, apparently.
Yeah,
Yeah.
so-
Just
so
by the
that-
way, Virginia, we've been trying that in Washington for 20 years, and I'm just going to tell you, it hasn't worked out yet.
Yep.
So,
And if you were Virginia, though, I mean, what with the current districts as they were drawn, the current makeup of the legislature, and then you get a Spanberger in there, never mind the fact that she didn't actually run on it. The writing was on the wall at that point.
Yeah.
So,
well,
I just-
especially because what you could take a look at what happened in last year's Virginia legislative session, because they passed a bunch of gun
Right.
bills last year. I don't think they passed 11. It was like 4 or 5, and Youngkin just, nixed them all. So many of those state legislators were back at it again. It's just the problem is they had more numbers. There was an
Right.
absolute. It was just this. They got smoked in the elections in the House. So the numbers were there, and yeah.
I mean,
It's too bad they have that weird one-term governor rule in Virginia, because Youngkin probably would have won re-election if he could have. But they have this weird rule there where you only get 1 4-year term, or you can run again, but it can't be consecutive. I think that's what it is. You can't-
That is, you got to sit out for, and then you can run again.
Yeah. I think what's his name, McAuliffe was governor, and then he ran against Youngkin and lost. But yeah, so it's a really strange rule, but it's unfortunate for us because Youngkin is strong, and he probably would have won re-election.
Right.
Yeah.
You know who else has got a strange rule? Is the state of Tennessee. Their attorney general is appointed to an 8-year term by the state Supreme Court.
Wow.
That is weird. That is
8-year term, huh?
8-year term. 8-year term. Yeah. And there's really no way of holding him accountable. And they got an attorney general out there, Jonathan Skrmetti, who I actually was a fan of for a while up until he started proposing a Senate Bill 1958, which would basically bar citizens from suing on the constitutionality of a state law.
You can't actually do that, can you?
Well, they're going to try. I don't know if the bill's going to get anywhere. I did a video on it. In fact, Kostas, you would like the video because I actually never told anybody what state I was talking about. I used all of it as hypothetical, and I set it up like it was a Rob Bonta thing, right?
Yeah.
And it's like, and then when I said, if I told you this was California and this is Rob Bonta, you'd all be like, aha, I figured. I hate that guy. I was like, yeah, but the problem is I'm talking about Jonathan Skrmetti in Tennessee, and here's the bill I'm actually talking about. And the moral of the story is that, yeah, the shoe's pretty painful when it's on the wrong foot, isn't it?
Yeah, I mean, that's the thing. You can get pretty comfortable in these red states because stuff mostly goes our way on gun rights. But when something is going wrong, it's very, they have so much power concentrated that, yeah, it can be tough.
Well, and I think it's important that we call out bad legislation no matter who's drafting it.
Right.
Yeah.
And it's not without significance that this guy doesn't actually answer to the public. I mean, he's not elected. He's appointed by the Supreme Court. And the Supreme Court, I assume, is somewhat, if not entirely, insulated from the electorate as well in Tennessee. I haven't looked that up. But, when he's the one who's really pushing for it, yeah, he doesn't vote on it. But when he's the one who's pushing for it, he dodges all accountability.
Bingo. That is the problem. I'm going to be out in Tennessee next month, and I'm going to be talking to a lot of folks out there about how you guys got to start working about making your attorney general a little bit more accountable.
And when they're pushing a bill like that, regardless of whether that or not it would actually legally succeed, which seems like a really big stretch to me. But when you're pushing a bill like that, you just got to wonder exactly what sort of unconstitutional schemes the legislative leadership has coming down the pipe.
Right. Well, listen, we're going to wrap things up. But for those of you who joined us late, want you to know we had a healthy dose of nothing burgers again today. Duncan v. Bonta, the Gators Guns case, Grant v. Higgins, NAGR versus Lamont, Viramontes v. Cook County, all no listed at all whatsoever. No thumbs up, no thumbs down. They could be back on conference as soon as this Friday. These are our next 2 conferences. We will be back on Monday. You guys going to be able to join me again next Monday?
I think so.
Yeah, don't see why not. Yeah.
All right. Excellent. Listen, I hope the 2 of you have a very productive work week. Thanks so much. And for all of you who tuned in, I hope you guys have a great work week as well. and everyone stay safe. Thanks, guys, for being here this morning.
Thanks so much for having us. Always a pleasure.
Take care.